Hello, you're very welcome. I'm Cerise, and I'm going to take you through some things you can do if you are working in a shelter for abused women, and they are looking for advice on where to go or who to talk to. So the first thing I need to explain is the concept of locus standi. That is pronounced locus standi. What this means is that you must be entitled to appear in court and ask for something. In Ireland, we often call it standing, but it means the same thing. You must be entitled to ask the court for specific types of help. In most cases, all you have to do is show that the case the court is dealing with affects you in some way. This is known as interest. In other words, whatever the court decides in a case will have an impact on you personally or your property or your children. So, for example, if your neighbors make a huge racket late into the night and you can't sleep, you can get an injunction. But your friend can't ask the court to help you. You must ask yourself. The noise is not affecting your friend. It is affecting you, so you yourself must go to court and ask for help. So, it's time to talk about the Domestic Violence Act. To show that you have standing to ask for help from the court under the Domestic Violence Act, it is not enough just to show interest. You have to jump through a number of hoops before the court will even consider your request for help under the Act. This means that when you are trying to discover if that person in the shelter can be helped by the Domestic Violence Act, you must ask that person for questions. The first thing to ask the person is who attacked them or abused them. If they give you a name, ask them what is that person to them: father, mother, lover, neighbor, landlord, etc. Once you know their relationship with their attacker, you can ask yourself, in your head, does this relationship fit one of the following categories? 1. Their spouse. 2. Their civil partner. 3. Their intimate partner. 4. Their child. 5. Their roommate or fellow lodger. 6. The person with whom they have had a child. These are all the categories of relationship that are recognized by the Domestic Violence Act. Different types of orders under the Act sometimes have less categories into which you must fit your attacker. In other words, the first thing you have to show is that your attacker or abuser fits into one of those 6 categories. Remember also that the Act calls the victim the applicant, and the attacker is known as the respondent. Now it gets a bit tricky. 3 of the categories require nothing further. Just being married to your abuser, or in a civil partnership with your abuser, or having a child with your abuser is enough to get standing. Of course, you have to prove that you are indeed in one of those categories, but nothing further is asked of you. With the other 3 categories, the easiest way to explain about them is to look at the actual Act. On the screen here we have Section 6, which deals with the safety order. So remember we talked earlier about the 6 categories of applicant? Well, there they are. To ask for help in terms of the Domestic Violence Act, you must be connected to your attacker in one of these relationships. You must be their spouse, or their civil partner, or their intimate partner, or their parent, or their roommate or fellow lodger, or the parent of their child. Now remember that we said 3 of those required nothing else. And you can see them there. 1, 2, and 6 have nothing else to prove. But 3, 4, and 5 have further things that need to be proved. So for example, number 3, the intimate partner. You also have to prove that, if you wanted to, you could marry that person without committing incest. You also have to prove that you were in the relationship before you came to court. Number 4, a parent, has to prove that the child they are suing is over 18 years of age and is not dependent on you, the parent. Number 5 has to show that the applicant is over 18 years of age and that they are residing with their attacker not because of a business relationship, like a landlord and tenant, for example. These extra hurdles that need to be proved and known as internal requirements of that particular category of applicant. So the 3 questions again. 1. What is the nature of the relationship between the applicant, the victim, and respondent, the attacker? 2. Does that relationship fit one of the applicable categories? 3. Are the internal requirements of that category satisfied? If the answer to those 3 questions is yes, you need to advise that person to go and see a solicitor about bringing an application to court under the Domestic Violence Act. If any of those questions comes back with a no answer, then the Act cannot help that person and they must look elsewhere for help. If the answer to those 3 is yes, then your solicitor will tell you what sort of evidence you need to show the court in order to prove that the respondent is a danger to your safety and welfare. In other words, they are a danger to your physical safety, psychological safety, financial safety, etc. So the first 3 questions establish your standing, and the 4th asks you to prove your case. It is important to make it clear to the person you are trying to help that you are not a lawyer, but you are doing your best to steer them in the right direction. I hope this little video has helped. Good luck!